Welcome to EUPrivacyForAll Session54 on GDPR, Article 90, Obligations of Secrecy. Article 90 on Obligations of Secrecy lays down that Member States may adopt specific rules to set out the powers by the supervisory authorities in relation to controllers or processors subjects under Union or Member State law or rules established by national competent bodies to an obligation of professional secrecy or equivalent obligation, making it necessary and proportionate to reconcile the right of the protection of personal data with the obligation of secrecy. Each Member State shall notify the Commission those rules. A key recital in the GDPR is recital 164. It sets forth that regarding the powers of the supervisory authorities to obtain from the controller or processor access to personal data and access to their premises, Member States may adopt by law specific rules in order to safeguard the professional or other equivalent secrecy obligations within the limits of the GDPR. Recital 50 enhances that indicating possible criminal acts or threats to public security by the controller to the competent supervisory authority should be regarded as being in the legitimate interest pursued by the controller. However, such transmission should be prohibited if the processing is not compatible with a legal, professional, or any other binding obligation of secrecy. In Recital 53, it is made clear that the GDPR should provide for harmonized conditions for the processing of special categories of personal data concerning health, in particular regarding professional secrecy. Article 9.2i lays down that the processing of special categories of data shall not be prohibited if such processing is necessary for reasons of public interest in the area of public health, on the basis of Union or Member State law, which provides for suitable and specific measures to safeguard the rights and freedoms of the data subject, notably regarding professional secrecy. Other key inputs come from Article 9.3. Personal data may be processed for the purposes of preventive or occupational medicine, medical diagnosis, the provision of health or social care or treatment, when those data are processed by or under the responsibility of a professional subject to the obligation of professional secrecy. The obligation of information of data subjects shall not apply in cases in which the personal data must remain confidential, subject to an obligation of professional secrecy. A data protection officer shall be bound by secrecy according to Article 38.5. And finally, concerning the staff of supervisory authority, Article 54.2 makes clear that those members and staff should be bound by a professional secrecy obligation during and after their term of office. In Directive 95/46, it is laid down in Article 8, paragraph 3, that the prohibition of processing of special categories of data shall not apply where the purposes of preventive medicine, medical diagnosis, the provision of care or treatment of the management of health care services are processed by a health professional subject to the obligation of professional secrecy. In Article 28 on supervisory authorities, it is also highlighted that members and staff of the authority are to be subject to a duty of professional secrecy. What should accountable data controllers and processors get prepared for? They should pay attention to specific national rules that Member States may adopt to set out the investigative powers by the authorities in relation to controllers or processors bounded by an obligation of professional secrecy under EU law, national law, or rules established by national competent bodies. Such law will frame situations in which it is necessary and proportionate to reconcile the right of the protection of personal data with the obligation of secrecy. The Commission will be notified all national rules adopted in this frame. Controllers should know that indicating possible criminal acts or threats to public security to a competent body is prohibited if the processing is not compatible with a legal, professional, or other binding obligation of secrecy. There is no obligation of information of data subjects where the data must remain confidential because of an obligation of professional secrecy. Overall, medical diagnosis and the provision of health or social care or treatment shall be processed by or under the responsibility of a professional subject to the obligation of professional secrecy. Finally, data protection officers and supervisory authority staff are submitted to an obligation of secrecy under the GDPR. So the question triggered now is, will there be an harmonized approach on secrecy and the processing of health data?